Welcome back to the channel. Today's case is State of Texas v. Janelle Garza, a state jail felony unauthorized use of a vehicle that spirals into a credibility test, a drug use confession on the record, and a sentencing packed with strict rehab terms. You'll see a judge who starts neutral but quickly shifts into cross-examiner mode after spotting contradictions between the police report and the defendant's answers. The defense opens with a redemption arc: 6 months clean, reunited with family, steady work, but the court's about to probe whether clean really means clean. Then comes the curveball, a same-day drug test order, followed by a candid admission about marijuana use, and the judge's immediate employment restrictions around childcare. By the end, the court crafts a detailed deferred adjudication plan, with treatment, 90-inch minus 90 sobriety meetings, and education requirements, plus potential restitution and contact limitations. Stay sharp. Listen for the moment when a supportive narrative collides with the paper record, because that's where this sentencing turns. Would you weigh recent self-improvement over lingering rule violations? Let's break it down together, chapter by chapter, and see exactly how this judge balances accountability, community safety, and the possibility of change.
All right, court is calling 2023 CR 1642, State of Texas versus Janelle Garza. Can our parties approach and announce for the record for the state?
Hank Wilkins for the state.
Defense.
Elizabeth Russell for Janelle Garza.
Are you Janelle Garza?
Yes, Your Honor.
Counsel, you received all the discovery. Did you review it with your client?
I did, Judge.
Court will find that the state is in compliance with discovery. Ms. Garza, I'm showing you what's entitled Application for Deferred Adjudication of Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right. Ms. Garza, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in all the appropriate places?
Yes, Your
We've just heard the formal charge: unauthorized use of a vehicle, a state jail felony in Texas with a punishment range of 180 days to 2 years plus up to a $10,000 fine. The court confirms Garza reviewed the admonishments and signed everything. That matters because it undercuts any later claim of confusion. Note the key term: deferred adjudication. If granted and successfully completed, there's no final conviction on this case. If violated, the court can adjudicate guilt and impose sentence within that felony range. Question for you: with first-time felony status and claimed sobriety progress, should the court lean toward rehab and structure over incarceration? Or do the facts you'll hear in a moment push you?
Do you understand you're charged with the offense of unauthorized use of a vehicle that's a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes.
After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
We are, Judge.
Defense rolls out mitigation: long-term addiction, first felony arrest, 6 months clean, reconciled with family, steady employment, and a stated acceptance of responsibility. That's a classic foundation for deferred adjudication. Show current stability and insight, not just remorse. But great mitigation invites scrutiny. The judge will probe whether the underlying conduct has been fully acknowledged and whether the new stability is consistent. Engagement check: what carries more weight for you? 6 months of clean time and employment, or the specifics of the offense and any inconsistencies that follow? Keep watching, because the judge is about to test the credibility of this changed story against the police report line by line.
Anything you wish to say on behalf of your client?
Yes, Judge. Ms. Garza, at the time of the offense, had been a drug addict for several years. When she was arrested, it was her first felony arrest, and it scared her. It scared her enough to get clean and to get a job. Since May 10th of this year, she's been clean. She did it on her own without going to rehab because she couldn't afford to go to rehab. And she's been clean for over 6 months. She has reconciled with her mother, and she's been employed since June of this year. She is a different person than the person that committed this offense because she understood and is willing to take responsibility for exactly what happened and wants to move forward with her life. She understood a change was necessary. And I think the person that you see today is a different person than the person that committed this offense. So we would request you place her on deferred adjudication because of that for the 2-year period and just follow the state's recommendation, Judge.
And what did you do?
Like
No, with regards to this offense.
what did I do?
Yes.
What do you mean? What did I do?
I mean, you're here for unauthorized use of a vehicle.
Oh,
So what did you do?
We hit our first friction point. Garza admits taking the vehicle without permission. That supports the UUV charge. But the judge immediately references a police report alleging the victim was drugged after meeting a female at a bar. Garza flatly denies drugging and seems surprised that allegation is in the report. This is the credibility pivot. The court isn't just punishing, it's auditing the narrative. A denial can be accepted, but only if the rest of the record aligns. Viewers, quick question. If you were the judge, would a surprise at the report's content signal honest confusion or selective recall?
I took someone's vehicle without their permission.
All right, because the police report is saying, at least he's saying he was drugged after meeting a female at a bar. That's what you seem shocked. That's what's in the police report. Have you read it?
I went over it. It's just,
Yes.
I didn't read that exact part.
Oh,
that
yeah,
said
it
that
says-
he was drugged, but I understand.
So was he drugged?
No.
And then he said his debit card was taken without his permission as well.
I did not take his debit card.
Well, they found it in your purse. That's what the police report says. Because it says right here,
I don't
Victim-
remember them saying anything about that, and I
No.
don't remember having the debit card or anything.
it says, according to the original case number, victim had been drugged after meeting a female at the bar. Victim allowed the female to take him home in his vehicle. After waking up, he discovered his vehicle was gone with the keys, cell phones, and multicolored debit card. He found out later in the day his debit card had been used at a local gas station. The stolen vehicle, which is what we're here today, was found today, had the keys in the ignition, and had no signs of tampering in the steering column. Victim stated he never gave any consent to take or use his vehicle and wanted to process with charges.
The judge reads from the report. The victim's multicolored debit card was later found used, and crucially, found in Garza's purse during a vehicle search. Garza says she doesn't recall being told that and suggests she thought the card belonged to a friend. Here's the legal dynamic. At sentencing, the judge can consider a broad swath of reliable information, not just trial evidence, when shaping conditions. If the court credits the report, it treats this as aggravating conduct property beyond the car. If it doubts it, mitigation survives. For you, does I don't recall them telling me mitigate possession of someone else's card if the report documents it?
Victim gave us consent to process and search the vehicle. While searching the vehicle, victim's debit card was found inside her purse. So they're saying they found his debit card inside your purse.
Mhm.
You're saying,
No, I'm saying I understand what you're saying. I don't recall them ever saying that, or them telling me that, or of them ever saying that they found a debit card in the purse. If they did,
yeah, that's what they say right here.
I understand. I just don't recall them ever telling me that personally, or them ever bringing
Well,
that up
wait a
to me.
second. This is what the police report says. The debit card was a multicolored debit bank card. I also found a gray camouflage bag in the trunk with some work gear and victim's work identification card. Suspect, that's you, was advised of her rights and asked why victim's debit card was in her purse. Suspect said she found it in the vehicle and thought it belonged to her friend. The bag in the trunk, she said, was already there. She said she didn't know the vehicle was stolen. So the debit card was found in your purse.
Mm.
When you're drug tested,
Smart move by the court. Order a same-day drug test before pronouncing sentence. Sentencing is about present risk and compliance potential. If the defendant claims sobriety, an objective test locks in the truth. Judges often pair treatment opportunities with verification measures. Notice the sequencing. Test first, sentencing second. That signals the judge is open to structured leniency if current behavior supports it, or prepared to tighten conditions if it doesn't. Engagement pause. Do you think every I'm clean claim in court should trigger an immediate test? Or should judges rely on probation monitoring later?
today, what are the results going to be?
I'll be clean.
All right, so we'll do a drug test today, then I'll come back with sentencing. All right, are you all ready?
Yes, I think.
All right, we're back on the record in 2023 CR 1642. State versus Janelle Garza.
This is the turning point. Asked when she last used marijuana, Garza answers, yesterday. Defense mitigation highlighted 6 months clean. But now we learn that meant clean from methamphetamine, not subs. The judge's reaction is about definitions. In court and probation, clean and sober typically means no illegal substances. This doesn't erase her progress off meth. That's significant, but it complicates trust. Expect conditions to reflect the need for structure, transparency, and treatment. Audience question: does ongoing marijuana use in
So when's the last time you used marijuana?
Yesterday.
All right. So what your attorney was singing your praises about how you've gotten your life together and you did it all on your own. So why are you using marijuana?
Well, I guess I should say I got my life together. I used to use meth for 5 years.
I'm sorry, what?
I used to use meth and
Yeah.
amphetamine for 5 years. That's what I've been clean for the last 6 months.
But marijuana is illegal here in Texas. So why are you using marijuana?
It just helps me with my anxiety. That's basically it.
All right. But as a part of the program
I
and
would
taking
know.
responsibility,
Yes,
when
ma'am.
your attorney was singing your praises, talking about how you clean and sober, you
Yes.
know that sobriety does not mean that you're using marijuana. You should have stopped her and said, wait a minute. Let me tell you something. But you didn't. You waited till you got caught.
I mean,
You did.
that's your opinion, yes. And
No, that's true. Let me ask you this. Did you interrupt your attorney and tell her, I'm not clean and sober because I'm using marijuana? That's yes or no. Did you tell her that?
I told her that I was using marijuana, yes.
When you were before the bench.
But because I just feel like there's different types of sobriety. For me, the meth use was really bad. So,
Well-
and I couldn't carry a job for the last 5 years. And in the last 6 months that I have been sober from methamphetamines, I have been able to get a job and get a car and see my daughter every day and be a mom and be present.
The judge immediately restricts employment. No nanny work, no home health care, especially while not clean and sober. That's a public safety calculus. Access to vulnerable people demands heightened trust, even with family involvement. Courts minimize risk during early supervision. Practically, this closes the door on certain jobs, but opens a lane toward education or trade credentials later in the sentence. Think of it as risk triage. Limit exposure now. Reassess after verified compliance. Would you impose the same blanket restriction at this stage, or allow closely supervised childcare with verification?
You're not allowed to use marijuana while you're on probation.
I understand that. And I understand that I would not be able to use it and I won't use it.
But do you understand you're not clean and sober?
Yes. And
So what do you do for a living?
I'm a nanny.
Oh, not anymore. I don't allow people on felony probation to be nannies, to be home health care providers, and especially someone who's not clean and sober. And who are you a nanny to? Is this a relative or somebody?
Yes.
Sister, cousin, who
Yeah.
is it? All right. So that job is over with today. You understand?
Yes.
So how far did you go in school?
I went all the way through high school. I graduated and I went through some trade school. I had my medical assistant. I went through medical assistant school. I finished that.
And where are your children?
Right now she's at school.
And how old? Do you only have one
I only
child?
have one. She's 14.
And does she live with you?
Yes. And my mom and my grandparents and my other family.
When you say your mom, your grandparents, and other family, what is other family?
My aunt, my other aunt, there's a whole bunch of us that live at my grandma's house.
All right.
Here's the structure: $500 fine, probated, 3 years deferred adjudication, TAP, evaluation, treatment assessment, and 90 meetings in 90 days. This is a rehabilitation forward sentence with teeth. The 90 and 90 builds immediate routine and sober community ties. TAP customizes treatment intensity, inpatient if needed, or intensive outpatient to start. Crucially, a level test for marijuana will track whether usage is tapering or escalating. That data point becomes a compliance barometer. How would you feel checking in daily, hitting meetings, and
This is what the court is going to do. Are there any other questions?
No, Your Honor.
All right. There's a $500 fine that will be probated. 3 years deferred adjudication. Going to do a TAP evaluation, follow recommendations. If they recommend inpatient treatment, we'll start with intensive outpatient treatment. There's going to be 90 sober meetings in 90 days. I'm going to want her tested for levels. If the marijuana levels go up, then we're going to address that.
Yes.
There is going to be the UA hotline. Regular reporting by Zoom or in person.
The court layers in education, trade completion, and 100 hours of community service. With credits tied to parenting classes and successful schooling, that's smart sentencing design. It converts punishment time into skill building that outlasts probation. Add proof of employment within 30 days and you get accountability plus a path to stability. Restitution is flagged. If the defense disputes the number, the court will hold a hearing fair process for both victim and defendant. Engagement check. Should community service convert to class credits, or should they remain separate to ensure both consequences and growth?
100 hours of community service restitution. Parenting classes. Once she completes parenting classes, 50 of those hours will be deemed to be satisfied. You're either going to get a higher level education, or either you're going to complete trade school or whatever you're going to do. That's going to be required. And once that's completed, then the remaining of the community service will be deemed to be satisfied. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors.
Other than her daughter, accurate?
No unsupervised contact with minors.
With her.
I'm sorry?
I won't ever be unsupervised with her.
I'm sorry, what?
I won't ever be unsupervised with my daughter.
All right,
My mom always is there with her.
thank you.
Mhm.
And do you have any CPS history?
There was a long time ago, but they were both closed and dropped
All right, and what was the CPS history concerning?
due to my meth use.
Okay. I'm going to want field visits.
We get field visits once a month for 3 months, then easing 2 quarterly if compliant. That's a carrot and stick approach. Prove stability, reduce intrusiveness. There's also no employment with minors and no unsupervised contact with minors other than her daughter, plus no contact with Josiah Hernandez, and restitution processing through probation. Translation: the court is walling off risk areas, monitoring early, and then rewarding consistency. If the restitution number feels inflated, defense can litigate it. Due process preserved. Question for you: is this the right balance between liberty and supervision, or would you tighten it further given the report details?
1 time per month for 3 months. And if there are no issues, then it'll be 1 time every 4 months. Restitution, if any, and no contact with Josiah Hernandez and counsel. If there is restitution that's determined by probation and you think it's inappropriate, you can come back for a hearing.
Judge, I do think we're going to need a hearing. They've submitted numbers to restitution that we believe is inappropriate.
Okay. All right. And probation, is there anything else she needs?
Your Honor, I apologize. He said restitution if any and no contact with Josiah Hernandez.
Yes. And it's Josiah.
Thank you, Judge. Nothing else, Judge.
Is there anything you need from the court to be successful?
No, Your Honor.
All right.
We briefly step into a related matter on the docket. Mr. Chrisman, an affirmed judicial stance on inpatient treatment at lifetime recovery, plus frustration over missing military records for a veterans court referral. Why include this? Showcases the court's compliance culture when paperwork lags or treatment is dodged. The judge locks in structure, inpatient now, documentation sorted inside the program window. Back to our main case. This context explains why Garza's plan is so detailed. the court calibrates opportunity with verification. Final engagement. After seeing both matters, do you believe the judge's approach is too rigid, just right, or not strict enough for public safety?
And then, if you all want, Ms. Ferguson will set it for a restitution hearing. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Mr. Crispin, I don't understand why you're here. You're supposed to go to inpatient treatment, the end. No, you're supposed to go into inpatient treatment, the end. So you're scheduled for lifetime recovery on November 14th. That's where you will be. I believe it's the 14th. Here's the thing. I don't know. I think you're here to talk to me because you don't want to go to inpatient treatment. Is that correct? No, my question is, do you want to go to inpatient treatment? Yes or no? All right, you're going into inpatient treatment, Mr. Crispin. We've been dealing with your matter for months now. So you're scheduled for inpatient treatment. That's where you are headed. Oh, no, he's going to go on his own to lifetime recovery.
Okay. Last time we spoke, you were still up in the air.
Mr. Crispin, I want you to hear me carefully. All right. You are going into inpatient treatment at lifetime recovery. The end. Sure.
Thank you. Why is there a double whammy on the same project?
I'm sorry, what?
Why is there a double whammy?
There's not a double whammy. You never bring documents that are requested of you. No, here's the first thing. One, you were supposed to bring documents of the military service to Veterans Treatment Court. They never received it. Yes.
Okay. I went and told you on the SSI office.
Do you have it?
I didn't even receive it. I have a one.
No. My question is, do you have your military records?
I have to have an addendum with the U215 addendum because my social's off here and my birthday's off in the Social Security office. The only way they're gonna accept it is I had to get a birth certificate. By the way, I get a birth certificate, because I had to have my father be living in California or it's taking even longer. I was 30 to 60 days to get, because that's what we spoke about.
All right, so Mr. Crispin, this is what we're going to do. While, Mr. Crispin, this is what we're going to do. While we are waiting you to get those documents, you'll be in inpatient treatment at lifetime recovery. And then lifetime recovery will make sure you have ample opportunity to get whatever paperwork that you say you need. But this has been going on for a long time, Mr. Crispin, and it's been going on too long.
So I understand that. Maybe it's just of the boards. Like.
Right now, ready to go. And now the judge can actually order for you to go to the leniency to do that process.
No, I'm gonna go and go in my direction. I always have with this part too as well. So whatever you say, I have to do.
Okay.
I'm just asking for the eligibility to talk to you because my only confusion is that we spoke about it and then you gave me pressure on that for the 90 days.
No, that was never addressed. For example,
I gave forms for the 90 days.
no, let me just tell you this. I had already put in place that you were supposed to do 90 meetings in 90 days. 90 meetings, time out. 90 meetings in 90 days is not taking the place of you not doing what the court has asked of you.
In State v. Garza, the court granted 3 years of deferred adjudication with robust conditions, TAP evaluation with potential inpatient or intensive outpatient treatment, 90 meetings in 90 days, substance testing with level monitoring, education, trade, completion, community service, with credits tied to parenting classes, employment verification, no work with minors or home health care, restricted contact rules, field visits that taper with compliance, and restitution, subject to a hearing, disputed. The judge weighed mitigation, 6 months off meth, work, family support against credibility issues from the police report and the marijuana admission. The takeaway, rehabilitation is available, but it runs on honesty, structure, and verified sobriety. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.